Hi everybody, trademark attorney Josh Gerben. I'd like to talk about what filing basis should you use in your trademark application. This is one of the most complicated and technical questions in any trademark application. It comes after you tell the government what trademark you'd like to register. Then you answer the question about what goods and services you're going to be providing under the trademark. Then you get to this question about what is your filing basis. And there are four common choices for a filing basis on a trademark application. The first is a Section 1A basis. This means you have an actual use in commerce of your trademark. The second is a Section 1B basis. This means you have an intent to use the trademark in commerce. The third is a 44D basis. This means you have an application for the same trademark in a foreign country. And finally, we have the 44E basis, which is that you have a registration for the same trademark in a foreign country. So let's walk through what each of these filing bases means and which one might be appropriate for your application. So in order to claim a Section 1A actual use in commerce for your trademark application, you have to actually be offering the goods or services listed in the trademark application, and in many cases have sales of those goods or services actually occurring. This is one of the most common errors that we see in trademark applications as trademark attorneys, is folks trying to make a claim of use in commerce too early. So for example, clients may say to us, oh, I formed the corporation or I bought the domain name, therefore I'm using the trademark in commerce. And that's just not the case. If you're selling products, typically to have an actual use in commerce and file under Section 1A, you have to have sales of your products that cross state lines. And it can't just be sales to your best friend or your mom. They have to be actual sales to clients or customers that would just find you in the general course of doing business. If you're a service provider, you typically have to have actual clients for your service, again, that would come from more than one state. So you could have a single location, like a single restaurant, but the idea is that people from at least more than one state have visited the restaurant before you'll have an actual use in commerce under federal trademark law. So the danger in claiming that you have an actual use in commerce when you don't is that you could get a registration that someone may come back and ultimately try to cancel based on a fraudulent or incorrect statement that you make in the application. So very important not to make this claim of a Section 1A use in commerce unless you're truly meeting all the requirements under federal law. So this brings us to our next filing basis, which is a Section 1B. A Section 1B filing basis is based on an intent to use the trademark in commerce. And the reason that this filing basis exists is that if you're starting your business and you want to buy a domain or you want to start getting your product packaging together, get your website built, and you want to reserve rights in your name and you don't want anybody else to come in and take it while you're getting all those things going, you can file an intent to use application. And in most cases, the federal priority date on your trademark will be the day you file the application. So if you filed your application in November of 2019, but the registration doesn't ultimately actually issue to December 2020, your rights will always be retroactive to that filing date in November 2019. So using an intent to use application to reserve your rights federally on your trademark can be a very good legal strategy. Now, two of the lesser used filing bases are the 44D and 44E basis, and this is because they're based on foreign applications or registrations. But even if you're a United States business, you may find using these filing bases to be helpful, and here's why. So let's say you have a trademark filed in the UK or the EU or Australia, or for that matter, just about any country around the world. When you file that trademark application, you then have 6 months in which you can make the US filing and have the US filing be retroactive to the date of the foreign filing. So think of it this way. You file an application in the UK on April 1st, 2019. So long as you file your US application by September 30th, 2019, your US priority date will be backdated to the date of the UK application on April 1st. So this is a really cool strategy that you can use for a number of reasons. One, let's say that you are a UK-based business and you want to get rights in the United States. You can file based on that UK application as long as you get it done in the US within 6 months. But if you're a US-based business and you don't think you're going to have actual use in commerce of your trademark for a while, you might go ahead, and if you want to have rights in another country, you might go ahead and file that UK or EU application. because then when you use that as the filing basis in the US, the only thing that has to happen is that UK or EU application mature to a registration. And in those cases, you typically don't have to prove use in commerce in the UK or EU to get those registrations. So if you get the registration issued in the UK or the EU, you then can get the US government to issue your federal trademark registration in the US based on that foreign registration without ever having to prove an actual use in commerce in the US. Typically then for the first 3 years your mark is registered here, nobody can even challenge it on grounds of non-use. So there's a really intricate strategy there that you can use foreign trademark applications to assist in the registration of a US application if you're a US-based business or if you're a business from overseas. So I hope you found this video informative. As you can see, there are 4 common filing bases that you can consider when filing a US trademark application. And you should be extraordinarily careful if you're going to claim a Section 1A or use in commerce basis, and make sure you're actually complying with federal law about what use in commerce means. So thank you for listening, and I'll talk to you next time.